here at club fairs and at different informational events. So to those familiar faces, thanks for coming back. And for those of you who are just really excited about antitrust law and don't know where to start, we've got little flyers scattered around the room. They've got access to our website, to our mailing list. Feel free to take them, scan the QR codes, and that will be your in to all things antitrust law here. This event would not be possible without the collaboration of our wonderful board and also of the Law and Political Economy Society here at Berkeley Law. And so I'd like to pass the mic off to Sam Mesfin to just say a couple of words on behalf of the LPE Society here.
All right. Hello. Okay. Thanks, Zara. Just want to say a few words explaining what LPE is and putting onto the schedule some events we'll be having in the near future. So first, the LPE project is a movement of scholars, practitioners, and students that analyzes the relationship between law and political economy. The best way to understand this is to recall a point that Professor Syed raises in each of his courses. Certain doctrinal developments occur across the discrete legal categories like contract, tort, property, IP, and these doctrinal developments largely track developments in political economy and indicate changes in structuring social relations. This implicates politics, social theory, history, forces which both determine and are determined by law. The LPE project analyzes the relation between law and these forces in the structuring of social relations. While we'll be zooming in on antitrust today, we'll also do bird's eye view analyses of these forces and their relationships with law, as well as looking at specific doctrinal areas. Keep an eye out for an event with Professor Syed on legal theory from an LPE perspective. And if you're interested in becoming involved with LPE, come by our informal interest meeting next Tuesday. It's going to be in room 145. And if you can't make it, email this email address and we'll reach out to you. Pass it back to Sarah. Thank you.
Thanks, Sam. And thank you once again to the entirety of the Antitrust Law and Economics Association Board, as well as the LPE boards for all of their hard work putting on this event. Now, I have the pleasure of introducing our speaker. We could not be more excited to welcome Professor Talha Syed here this afternoon. Professor Syed's research work focuses on law and political economy, as you've just heard from Sam, and its application to fields such as intellectual property, distributive justice, torts, and of course, the reason we're here today, antitrust. To many of you in this room, Professor Syed is a familiar face, as many of us have had the pleasure and privilege of being in one of his classes. And for those of you who have not had such an opportunity, you're in for a real treat this afternoon. With that, I'll head off to Professor Syed.
All right, terrific. Okay, so thanks, Zara and Sam. Let me start by saying thanks very much to the incredible student energy behind the Law and Economics of Antitrust and LPE societies at Berkeley for organizing this. I think it's part of an incredibly exciting ferment that we're experiencing in our society and law schools. I grew up under what I like to call the glacial period of neoliberalism, where from roughly 1980 to 2016, history was over, ideology was finished, politics was micro, and nothing much mattered. It was a glacial period in which there was a dominant framework which structured most thinking and practice in law and politics. Since then, I think we've been in a period of great ferment, of potentially fundamental realignment of the basic institutional and ideological premises undergirding our politics and law, one that hasn't existed since the 70s. And so you're all going to law school at a time when this is happening. And so I'm going to talk a bit about what that means for antitrust in the course of the talk, but I sort of want to frame it that that's part of what I think antitrust, why it matters today. It matters because it's a central field of law in this overarching debate about the tectonic plates of our overall political economic system and legal system. So for this talk, I want to focus on four things. First, what is the basic structure, the basic subject matter of antitrust and its basic structure as a field of law? Second, what are the central policy debates in antitrust as a field of law? Third, what are the theoretical premises behind competing policy positions in that debate, and what are the historical contexts in which those theoretical premises developed and rose and fell. And then finally, some implications for why it all matters today. So that's sort of the law, the policy, the theory and history, and the practical implications today. So let me begin with a very seemingly elemental point, but important one, I think. Antitrust is a very weird name for this field of law. It's an extremely provincial name that's only adopted in the United States. The rest of the world doesn't have that name. It has the proper name for this field, which is competition law. In the United States, it's called antitrust because of the historical origins of the field, which was to bust the truss, which developed in the late 19th century. And the truss were complicated legal arrangements undertaken to facilitate conglomerate ownership in the wake of resistance by state laws towards corporate organization. That has long since passed, and the trust is no longer a legal vehicle for anti-competitive or cartelizing or monopolizing conduct. And so this area of law is really competition law, not antitrust. That's a sort of anachronistic name. And because the United States is such a central player in global political economic developments, it arrogates itself the right to continue calling this anachronistic name. But in the rest of the planet, no one knows what antitrust would mean. It's competition law. And the fact that it's competition law has important orienting points, in particular three. The guiding aim of this field of law is to secure adequate competition. And a lot of debate is what is adequate, and we'll talk about that in a minute. But that's the aim. The aim of this area of law is securing adequate competition. And this signals an important limitation of the field. The field is about ensuring adequately competitive markets. But there can be problems of socioeconomic justice with markets even when they're competitive. Okay, so competitive markets are not the be-all and end-all of socioeconomic justice. Yet, if you have a problem with competitive markets, that problem is probably best taken not in antitrust law, but elsewhere. Antitrust law focuses on ensuring adequately competitive markets. But of course, even adequately competitive markets can have problems, and those problems require other fields of law and policy to address, not antitrust. It's important to understand this because I think many people mistakenly take the view that all questions of economic justice have to do with antitrust and anti-monopoly, and I would suggest that that is a mistaken view to orient yourself in the field right at the outset. Third point. Because the aim is to ensure adequate competition within antitrust law, competition is the yardstick, the beacon. Everything good is called pro-competitive. Everything bad is called anti-competitive. And this applies even when the good things are not really increasing competition, but producing some other good economic benefit, such as efficiencies from economies of scale and scope. Yet this is still called pro-competitive. This is like a weird rhetorical tick of the field, which has an effect which can be to short-circuit thinking to some extent. Everything good is pro-competitive, everything bad is anti-competitive. This is just how the field operates, and it's important to understand that those are just synonyms for good and bad, and not always is something good, in fact, increasing competition necessarily. So this is just sort of to orient ourselves with the field in terms of its orienting agenda. So the central aim is to ensure adequate competition. And in particular, the central structure of the field is quite simply put as follows. The fundamental competing consideration in antitrust law or competition law to adequate competition are the benefits of coordination. Every aspect of antitrust law is about weighing the benefits of competition, which is typically decentralized, against the benefits of coordination. And that's the central structure of the field. And that structure then plays itself out in four main areas, which I'm just going to briefly list and then move on to more fundamental questions of policy and theory. And the four main areas of antitrust law are regulating horizontal competition, competition between present or would-be competitors, vertical relations between partners up and down a supply chain or distribution network, unilateral conduct of a firm acting on its own. Those are the three main areas of competition law. And those three areas are typically regulating conduct after the fact of some troubling or potentially troubling practice has arisen. Ex post regulation of conduct. Those same three areas, however, can happen ex ante beforehand, not in regulating conduct, but in regulating structure. And that happens with mergers and acquisitions law, where similar considerations of weighing the benefits of competition against coordination with respect to horizontal, vertical, and unilateral effects takes place not after some conduct has happened, but before some proposed new structure of firms integrating is before the agencies and the courts, and they have to regulate whether or not to allow it to go ahead, to forbid it, or to allow it with conditions, mergers. So that's a sort of rough field, overview of the field. Those are the four main sub areas underneath the overarching structure of how to weigh the benefits of competition against the benefits of coordination. Okay, with that, we come to the central question, the central issue. So what's so good about competition? Why do we want to ensure competition and ensure adequate competition? Well, the best way into it is to understand what's so bad about the opposite. The opposite of competition is sometimes thought to be monopoly. I think it's better understood to be concentration. What's so bad about monopoly or concentration? And that tells you what's so good about competition. The standard analysis of the field is that concentration and monopoly has four distinct effects, which can be troubling. When there are few or only one firm in a market, that concentrated or monopolistic structure can result in, first, higher prices. Second, reduced output. Third, decreased variety or consumer choice. And fourth, dampened innovation over time or improvements in product quality. Prices, output, quality, variety. Those are the four central parameters in which the mainstream of the field evaluates the effects of competition against coordination. Now, within that mainstream, there is a central debate about what is the precise ill of higher prices or lower output or decreased variety and decreased quality. The mainstream I'm going to call the neoliberal mainstream, and what I mean by neoliberalism I'll unpack shortly. Within that mainstream, we can understand two main schools, a Chicago school and a Harvard school, two different schools of industrial organization and antitrust law and policy. One school, the Harvard school, says there are two problems with higher prices. Problem one is that many consumers are price gouged, price hiked, if you will. They pay more for a good or service than they would have otherwise paid for in a more competitive, less concentrated market. They pay more. Other consumers, meanwhile, are priced out. They can no longer afford the higher priced good in the monopolistic or concentrated market. Priced out, priced gouged, right? Two different effects. Some consumers get the good, but they pay more. Others don't even get it. The Chicago view is that only one of these effects should concern us. Those who are priced out. Consumers who are priced out means they could have paid the efficient cost of the good, the competitive price of the supply of the good, but they were priced out of the concentrated or monopolistic price. And as a result, they forwent the good and the seller forwent a sale. A mutually beneficial market transaction was foregone. That's called an inefficiency or deadweight loss. And that's a concern for both Chicago and Harvard. But the Harvard, and we can understand Chicago to be a kind of conservative approach, Harvard to be a more liberal approach, Republican, Democrat, if you want. The Harvard approach says, yeah, that's a concern, but there's a second concern. What about the consumers who aren't priced out, but they pay more? To which Chicago says, but why is that a concern? The transaction still happens. The surplus of the transaction is still realized. And whether the consumers pay more doesn't really concern us because it's not like that money goes up in the air. It goes into the pockets of the firms who then distribute it in some indiscriminate way between shareholders, executives, and workers. The Chicago view is why should price hikes independent of priced outness concern us? Harvard says, well, there's a transfer of surplus from consumers to producers. And Chicago says, well, why should that concern us? Producers are people too, right? Producers are people too. When you think of producers and you think of firms and managers and executives and greedy people squeezing, Chicago tells you, well, these people are just ciphers, stand-ins for stockholders who are nothing but pensioners. Don't you want pensioners to get their returns? Don't you want retirement accounts to be padded? And that's the debate in a very simple-minded way. The historical FTC position, Federal Trade Commission position, has been we care about priced out and priced gouged effects. The law and economics view within the mainstream of the profession has been no, we only care about the priced out, not the priced gouged effects. We only care about efficiency, not distribution. So that's one debate. Efficiency versus distribution as our concern. So we can summarize that debate by saying, within the mainstream, the Chicago view cares about adequate competition being efficient competition. And the Harvard view cares about adequate competition being fair competition, where fairness means distribution of surplus between producers and consumers. So that's one debate. What the substantive goals of the field should be. Efficient or fair competition, understood in the terms of total social surplus, Chicago, or consumer surplus, Harvard. A second debate between these schools, which is also importantly put on the table right away, is not about the substantive goals that should guide the field, but about your administrability assumptions, your default assumptions. Are you more concerned in a world of radical uncertainty and dynamic flux in ever-changing market conditions that court regulatory errors will be over-inclusive or under-inclusive? Errors will be made. Everyone accepts that. The question is, will the errors veer towards over-enforcement, over-regulation, or under-enforcement, leaky regulation? And so that's a second debate. Chicago is more concerned about errors of over-enforcement, and Harvard suggests that those are exaggerated, and the errors of under-enforcement tend to be downplayed. So one illustration of this is that when the Law and Economics treatise was first authored by Richard Posner in the 1970s, when the neoliberal framework was just becoming consolidated and ascendant, he proposed, with respect to antitrust, that we simply abolish Section 2 of the Sherman Act, which is the provision which regulates unilateral conduct. He thought the errors of over-enforcement were so great and the fears of under-enforcement so small that we don't even need to regulate when firms are acting on their own, only when firms are acting in partnership with others. And a review of that book by Frederick Scherer at Harvard cast doubt on that view, pushed hard against it based on a consumer surplus view and the history of antitrust policy. So that's a second debate within the mainstream. But now I want to step back and talk about the broader debate that we're now undergoing today. That debate within the mainstream, within what I'm calling the neoliberal mainstream, has been the main debate in antitrust since, roughly speaking, 1980 to, roughly speaking, 2016, 2018. Since then, we're in a major period of ferment. And that ferment is marked fundamentally by two things. Two claims about antitrust finally reawakening after almost a half-century of slumber. One central area of reawakening is the resuscitation of antitrust against big tech. In the last couple of years, the last few years, multiple suits against Google, Amazon, Meta or Facebook, Apple have finally begun to be brought after years, even decades of relatively little inaction against big tech. Indeed, about a decade ago, Richard Posner at a conference had proclaimed, "Isn't antitrust dead? What would we possibly do going after the big tech companies? They're America's best companies. It would be crazy to go after them with antitrust." That's the Chicago view. But many people, including Einar L. Haig at Harvard, have accepted that antitrust did fall asleep a bit at the wheel and, in fact, was under enforcing against big tech and does need to be revived. So that's one debate, whether or not antitrust needs to be revamped and reapplied against big tech. A second development, however, not about the application of antitrust to big tech, is the emergence of the neo-brandeisian movement in antitrust. The neo-brandeisian movement is named because it's understood to be a callback and a revival of an earlier period of antitrust before the neoliberal period, during the New Deal, which was called the Brandeisian period after Justice Louis Brandeis. And I'll say a bit more about that momentarily. The neo-brandeisian movement, the young Turks of antitrust, have as among their leaders Lina Khan, whose article in 2017 Yale Law Journal, Amazon's Antitrust Paradox, is understood to be a kind of touchstone flag in the field, signaling a new approach to antitrust. Not just a new approach to antitrust applied to tech, but a new overall philosophy and theory of antitrust. And of course, Lina Khan is currently the FTC commissioner. And so it's a very important moment, and the neo-brandeisians are very important players in the field. And so for the neo-brandeisians, there are 2 points. They agree with Harvard that antitrust has been asleep at the wheel for the last few years or even decades with respect to mergers, big tech, price fixing, predatory pricing, all sorts of conduct. But Harvard thinks that's because the tools of antitrust have been lying fallow and not picked up and used. It's an external concern that for some political economy reason, antitrust has been under-enforced. But internally, the tools of the field are just fine. But the neo-brandeisian view is no, there's a second point. The tools themselves need to be refashioned. Our understanding of the substantive goals of antitrust need to be changed. Our understanding of the administrability defaults of antitrust need to be changed. And those two apply to different sectors will result in relatively different doctrinal frameworks. That's the claim that is being propagated by the neo-brandeisian movement. And the neo-brandeisian movement starts its critique of the neoliberal consensus with a historical argument that neither the Chicago view of efficient competition nor the Harvard view of consumer-oriented fair competition were the guiding, driving aims of antitrust law at the inception of the field in the 1880s and 90s with the Sherman Act and then the Clayton Act and the FTC Act in the 1910s. Driving those legislative developments was not a concern with inefficiency. In fact, the particular kind of inefficiency that the Chicago approach focuses on wasn't really formalized until 1954. So that wasn't the driving concern. Nor was it only a concern with consumers being ripped off by firms. The concern was as much with the little guy, with farmers, small businesses, and consumers against the emerging, rising hulks, behemoths of the sugar trust, the oil trust, and how they would relate to their input suppliers, their output distributors, and their end consumers. The idea was these big firms are gumming up a competitive economy at various crucial choke points with various deleterious effects. And that concern was then consolidated in the New Deal era, at least retrospectively, as marching under the slogan, big is bad. Small is good, big is bad. And so that's a different view of antitrust than efficient competition or fair competition, as the neoliberal framework has it. It is an idea of small competition against big concentration. Everyone get it's roughly a different idea of what the guiding aims of the field should be. And one of the fundamental debates today is whether the neo-brandeisians mean to be reviving big is bad and small is good, or not just resuscitating that view, but reviving it with some refinements to offer a new fourth position besides the three that have dominated antitrust over the last century or so. And so that's one fundamental debate, whether the neo-brandeisian yardstick is going to be crystallized in a way that's differentiated from efficiency, consumer surplus, or small is good and big is bad. And I'll speak to that in a momentarily. But before I do, Zara, can you just tell me what time I started and how much time I have? You're joking, right? Okay, well, we'll give me 7 minutes and pretend it was 5. Thank you. All right, great. Because I now need to set these debates within a proper historical framework. All of American law, I suggest, has to be periodized in the last 150 years as going through 3 periods of development. In each period, there was a reigning paradigm, a framework, which governed most of the law and politics within that period, within a set of political economic premises of institutional and ideological settlement. And then there was a period of ferment, debate, and the tectonic plates shifted and realigned to result in a new settled framework. And I suggest we're in a period of ferment now. From 1870s to about the 1930s, the guiding framework for law and political economy in the United States, the guiding institutional ideological settlement, I think was best understood as classical liberalism. From the 1930s to the 1970s, the framework was the New Deal. And from the 1970s to the 2016s or today, the framework was neoliberalism. And antitrust law tracks these frameworks to a considerable extent. The classical liberal view was that markets are natural and left to themselves produce liberty and prosperity. Therefore, laissez-faire, leave markets alone. That's the couplet. Markets are left to themselves, produce liberty and prosperity, therefore leave alone. The New Deal period said, no, hang on. Markets left to themselves often, 1, fail to be competitive. 2, even when competitive, fail to produce socially good outcomes because of externalities, informational asymmetries, and other problems. Therefore, when markets fail to be competitive or produce socially optimal outcomes, you should regulate for the sake of improving social welfare. Not classical liberalism, but welfarist liberalism as a framework. Then comes along the neoliberal period. And its double slogan is, markets don't fail nearly as often as you think. Often what you consider a market failure is just a transitory phenomenon, which will be corrected soon enough by market actors, including what you consider a monopoly, which is just a transitory phenomenon of an incumbent succeeding in competition, but soon enough there will be new entrants, and the gales of creative destruction will take care of concentration. And even if market failure is a real problem, the government solution is often worse than the market problem. Government solutions are often informationally heavy-handed and regulatorily captured, therefore minimal regulation, which tries to mimic markets, is better than heavy regulation, the neoliberal period. And within antitrust, what happened during neoliberalism was an ouster of the New Deal view of big is bad, and its replacement with the slogan, the purpose of antitrust is not to protect competitors against competition, it's just to protect the competitive playing field. And our beacon is not small is good or big is bad. Our beacon is consumer welfare. And consumer welfare is ambiguous between total welfare, Chicago, or consumer surplus, Harvard. And now what we have is a debate where the neo-brandeisian view suggests, no, it is not just that we are concerned with price, quality, variety, output, understood in narrow price consumer terms. We are not just concerned with efficient competition or fair competition as consumer protection. Well, then what is it? Are we just wanting small competition against big? Perhaps. Or perhaps the concern is that we want competition to be robust, not just efficient or narrowly fair from a consumer surplus point of view. The concern is with concentration. Concentration in a market today can lead to not just economically maldistributed returns today, it can lead to economic incumbency tomorrow, and it can lead to political power the day after. Concentration today can lead to economic rents, which can lead to economic entrenchment, which can lead to political capture and a snowballing effect, where steps towards concentration today are reinforced and become deeper and more entrenched, with the effects of concentration not fully captured by higher prices on consumers today, but also by the shaping of markets and consumer preferences tomorrow, and the shaping of the regulatory environment the day after. A cumulative process of concentration of power. And if that's your focus, then the job becomes identifying both substantive goals and administrable metrics that can orient the analysis of anti-concentration antitrust in a way distinctive from neoliberal antitrust without necessarily collapsing back into big is bad, New Deal antitrust. That's what I would suggest is roughly my view, at least, of the lay of the land of the field today. Maybe I should stop here. Does that make sense? Okay, I'll stop here, and then if people have thoughts and questions, I'll take them up in that course. Thanks.
Okay, so we're going to move on to some of the questions that all of you have submitted on the RSVP form. Thank you so, so much for all of your questions. We hope that we can get to as many of them as possible. Let's start with what is antitrust? And maybe you can clarify the line and kind of interplay between federal antitrust law and other related fields like consumer protection law, international trade law, state antitrust, contracts, commercial law, and anything else.
Okay, terrific. So I won't be able to say much about many of these fields of law, but I do want to say something quite important about the intersection, the overlap, but also the distinction between antitrust and consumer protection law. So consumer protection law is an area of law with many statutory and common law doctrines, which I can't now unpack, but consumer protection law is also under the bailiwick of the FTC, the Federal Trade Commission. The FTC Act Section 5 is a broader provision than any of the other provisions regulating antitrust in the Sherman Act and the Clayton Act. The Sherman Act and the Clayton Act focus on competition. They focus on prohibiting restraints on trade that will be anti-competitive or monopolizing in some way. FTC Section 5 says, thou shalt not engage in unfair trade practices. Unfair trade practices is a much broader rubric than only anti-competitive trade practices. And the difference between them, I think, is fundamental to appreciate today. The difference is many trade practices can be exploitative or otherwise unfair to consumers or other parties in a market, even when they're engaged in by multiple firms, none of whom has market power, and none of whom are coordinating in any oligopolistic way. Even in relatively competitive and non-collaborating or colluding markets, there can be unfair trade practices. Why? Because all firms in the industry, in the sector, can realize there are certain informational asymmetries between them and consumers that they can all take advantage of in profitable ways, resulting in various race to the bottom transactions, boilerplate contracts, fine print in finance, et cetera, et cetera. So a major aim of consumer protection law has to be carved out as distinct from competition law. It's not about securing adequate or robust competition, but about regulating failures of competition, even in a competitive market, owing to informational asymmetries or other forms of disadvantage that parties face vis-a-vis firms in a given market. And this is really important, in my view, in one area of tech to think about. A lot of us are concerned with big tech, and a lot of us are concerned with big data. Data-based business models that are based on vacuuming up all our daily micro data, analyzing it in aggregated form to have information about patterns of buying, consuming, and other behavior, which patterned information is then sold to other firms for advertising or used by firms in shaping their products, their services, and the internet that we're going to see tomorrow. This type of conduct, I suggest, is going to be equally worrisome in competitive and concentrated markets. It's not the case that competitive markets are going to magically solve the problem of data-based business models. Data-based business models can exist even in competitive markets. The main problem with data-based business models isn't concentration. The main problem with database business models is simply commodification. Commodifying our time and attention today for the sake of deepening it tomorrow, so that we keep coming back with buzzes and ticks, have our eyeballs and ears glued, have our purchasing conduct be deepened in a specific set of grooves. That concern, if we have that concern, isn't a concern with concentration as opposed to competition. It's also, in my view, not only a concern or even primarily a concern with privacy. Even if the data is fully anonymized and aggregated, it should concern us. It's a concern about self-determination. It's a concern about autonomy. It's a concern about the environment and the architecture that shapes who we are. We are always shaped by our context. There's no way not to be shaped by the context. The question is, what are the architectural design rules for how that context itself is shaped? Should we have a laissez-faire view that the context that shapes us can be shaped solely by firms with commodification incentives? Or should we push back and have certain default architectural design rules which thwart against fine-grained, granular commodification of every nook and cranny of our time and space online? That is, I think, a different concern, very much at the heart of consumer protection, which is only somewhat overlapping with antitrust.
I think that leads us perfectly into my next question. You pointed out, big data is one area, but do you think there are areas where competition should not be kind of our guiding North Star? Are there markets where, we shouldn't have any competition, or what are your thoughts?
Well, that's terrific. I mean, there's two different points lurking in that question. One, are there markets where competition should not be our lodestar? Two, are there sectors where we shouldn't have any competition, meaning even any markets? And I think those are fundamental points and delimitations of competition law as a field. There are areas where breaking up economies of scale and scope may not be feasible or even socially optimal, where there are advantages to integration, to size and diversity, which seem ineluctably to snowball into incumbency or other firms who are not incumbents but new entrants but become big being dominant. In antitrust or competition law or public utility law, these are called markets that are structured as natural monopolies or natural oligopolies. And historically, before the neoliberal period, these were regulated utilities and sometimes treated as public utilities, in which one or a few firms could engage in the investment infrastructure such that the market demand at the back end was too small for multiple firms to engage in duplicative infrastructural entry costs. And therefore, rather than break up or make available to competition, these sectors had to be regulated. I think regulated utilities and public utilities are due for a comeback after a long period of disfavor in the neoliberal period, and they have to be understood as adjacent, synergistic, complementary tools to antitrust regulation. Not every area can just be breaking up or involving competition as our solution. Finally, I think there are contexts in which it may be that we should have a greater role for the public sector to be involved in economic activity alongside of market actors, whether those market actors are in a decentralized competitive market or a more concentrated, regulated public utility model market. And so I'm working on one area, pharmaceutical innovation, where I think a greater role for public sector involvement is probably merited at certain stages of the innovation process alongside private sector firms, and there can be other areas like that. And so I think we should take very seriously the idea of social utility models, especially in areas where the advantages of integrated, concentrated size of diversity, scale and scope are very high, and the concerns they pose are very high. We should probably have public sector entrants which can provide an alternative to market-based business models as a competitive check on them.
And I think you've already touched on this on some level, but let's go back to kind of the big data monopolies or firms out there. Just spell out for us how Chicago style or Harvard style antitrust works there. Like when consumers aren't paying for the goods, how do we do priced out or price gouged?
Yeah, so I mean that's the biggest and most interesting and important question, I think, that is raised by, of course, Amazon and Google, right? In the case of Google, I'm pretty sure none of you have ever paid to use Google search engine. I know I haven't. And so if the concern with Google is understood solely in terms of your market concentration will lead to higher prices, which will price gouge some, price out others, that concern can't be operationalized with respect to us because we're not paying anything. Shift over to Amazon. The concern with Amazon can't be in the first instance higher prices. We all understand. Amazon has basically been incredibly successful in lowering prices and increasing diversity and lowering shipping costs, to the point that many people believe they're predatorily pricing for many, many, many years, undercutting everyone else in a way that's making losses for the sake of becoming the dominant player and then down the road raising prices on us. In both these cases, if price is your only indicia of concentration, there's nothing to see here. So we have to develop, if we're concerned about these two firms, other indicia of concentration. And the other indicia have to be, first instance, about variety and quality. I think it's a common experience, I assume it is, that Google search engine has become increasingly to suck over the last many years. It's deteriorated. It used to be amazing, and it's become more and more deteriorated in its quality. And at least part of that has to do with a lack of competitive check. and its business model being used in ways to favor incumbent businesses and incumbent partners in ways that are not responsive to consumer preferences. And so how do we get at these deleterious effects on variety and choice and quality when price is itself not the best indicator? That's one big question. And then the other one is data. Much of the business model of Google, of course, but Amazon as well, Facebook as well, even Apple, is based on access to, sorry, not Apple, based on data. And so there we might be able to use price again, but now not for end consumers, but for the intermediary players who, when facing big firms which are vacuuming up big data, will predictably start facing higher prices for access to that data. So intermediate players in the supply chain, you might be able to use prices to track the concern of the choke points along those supply chain distribution networks. But when it comes to the end consumer, the concern about data, again, is not a concern about price. So we have to broaden the parameters beyond price and output, which were the two leading sort of guiding posts in the last 40 years for anti-competitive harms, to include, of course, quality and variety as much more central to the analysis, but also to the extent that even those concerns aren't fully captured in database business models, we might have to leave competition law and focus on consumer protection based on other concerns which aren't easily operationalizable using the metrics of antitrust.
Now that we're on Google, can we get your views on the recent Google case and how this weighs in on how we think about administrable remedies in antitrust?
So what do you mean by Google's implications for administrable remedies? Because you can say more.
Yeah, I think my understanding was that there was a new and innovative way that the trial court had dealt with the claims in the Google case. I'm not entirely sure, but this is a question coming from the audience as well.
So I am not totally up on that, and so I can't actually speak to the innovative administrable move by the trial court. The basic points in the Google case involve application of, to some extent, traditional theories of exclusive dealing as applied to Google. But in a case like Google, when one firm is engaging in exclusive dealing, telling other firms how to prioritize their search engine if they want their business, those sorts of deals, which are commonplace in the market, have to be scrutinized much more severely when they're being done by a firm with such dominant market power. So just as an administrability matter, how much market power you have can very greatly affect how much concern we have about the same conduct. And so Google doing something should concern us much more than a firm without that sort of market power. And that's one way of having an administrability remedy in the case of Google or Apple or Amazon. But other than that, I can't really speak to the specifics. I haven't followed the specific case that closely, and so I don't want to say anything.
And for our final question, maybe you can say more about how antitrust works in the pharmaceutical industry, since I know you're kind of an expert in the pharmaceutical industry.
Okay, well, great. Thank you for that nice, lovely layup. Okay, so I wanted to say a couple of things. One about antitrust and intellectual property in general, and then one about antitrust and IP in the pharma context. But I'll do it, no, I'll do it that way. Okay, so in general, there's been a lot of uncertainty, confusion, debate about the extent to which intellectual property rights pose an antitrust concern. And the debate in the field has had various different positions. One position is intellectual property rights tend to confer monopoly power, and therefore they tend to raise antitrust concerns. That was a common view in the New Deal era. A second view, which became ascendant in the neoliberal era, is that intellectual property rights don't tend to confer monopoly power. They're just property rights like any other, and therefore they're not raising any special problems for antitrust. They're inherently compatible with antitrust so long as they're being exercised within their scope of the right. In a forthcoming article, I argue that both of these positions are just fundamentally wrong and misguided. like just at a fundamental level. Intellectual property rights, the concern with them has nothing to do with monopoly power. It has everything to do with the fact that they're property rights. But they're property rights over a resource, information, which is peculiar, being non-rival. And therefore, property rights, exclusionary rights over that resource always come with a cost. The point is to allow people to mark up to incentivize the generation of the innovation. That's the fundamental point of intellectual property rights within IP. We allow a markup today to recoup costs of innovation yesterday. As a result, from an antitrust point of view, IP rights should be presumptively understood to always confer market power. But that doesn't mean they raise anti-competitive concerns, because market power by itself is neither necessary nor sufficient to raise concerns in antitrust law. It depends on how you got that market power and how you're wielding it. And that analysis, when applied to IP rights, has to be much more nuanced than either of the prevailing views that they tend to be presumptively troubling or presumptively untroubling. No, they may or may not be troubling depending on how they're being wielded. And that's a separate way of analyzing the intersection than the common ones in the field. Now, with respect to pharma, what's very peculiar in pharma is that in this industry and no other, there's a typical form of settlement between a patentee firm and a defendant, generic drug company. Typically in patent litigation, when a company settles with the defendant, a plaintiff settles with the defendant has to pay the plaintiff some amount of money to avoid getting damages for infringement down the road. Typically, the defendant pays the plaintiff some damage, something short of the prospective damages, and therefore they settle the lawsuit and the plaintiff drops it. In pharma and pharma alone, it is the plaintiff, the patentee, who's paying the defendant to drop the lawsuit. These are called reverse payments because they're reversed from the usual. And the concern is, of course, that the patentee is paying the defendant off from challenging a weak patent so that they can delay the entry of the generic drug. And the question is, why are these only happening in pharma, and how should antitrust deal with them? And in a forthcoming article, I argue they only happen in pharma because pharma is the only context where there is a fully developed generic industry which is involved in patent litigation against patentees. So in a smartphone litigation, you have Samsung against Apple. Both are innovators. Both are engaging in innovative conduct, and therefore their profiles are not that distinct. In pharma and pharma alone, the defendant is an imitator who is involved in replicating a patented drug and providing a low-cost variant once regulatory approval is allowed. That industry structure is peculiar to pharma, doesn't exist elsewhere. And as a result, these deals, I argue, should be just presumptively, not just presumptively, per se anti-competitive. They should just be held simply anti-competitive. They're a form of market division between horizontal competitors over time, and they should be simply disallowed. In the pharmaceutical industry, there are a series of perverse incentives which enable patentee firms to game the system in various ways to prolong their effective patent life. But the fundamental point is that the incentive that pharmaceutical firms have to prolong their patent life is stronger than in any other sector in our economy. Because when the drug goes off patent, a generic firm enters, and the gap in price is much greater than the competition patentees face in any other sector. So that's the fundamental difference in pharma, and that's the fundamental reason the pharmaceutical industry should be treated differently than others.
Wow. This has just been absolutely fantastic. Can we get one more round of applause for Professor Syed? If this has made you super, super, super excited about being an antitrust lawyer, please join us on the 25th for the, for us, we're gonna invite members from the FTC, the DOJ, and the California DOJ to do a panel on enforcement. And then on October 3rd, we'll have a whole bunch of antitrust defense lawyers talking about antitrust defense. Thank you.
So you just want, you don't want to lock them up?